to be back. Call the first case, please.
JCR LLC Et al. Versus Vicki Hance Et al.
We'll hear from the appellant. You ready?
May it please the court. I'm Jim Moore of the Knoxville Bar. It's always a special day to argue an appellate case. Although my first time, nothing will beat my first time where Judge Parrott scheduled me in front of the whole entire law school for my very first appellate court argument.
Everything after that should have been simple.
It had definitely seemed that it's simpler than that. Yeah. We're here today on actually two cases that were consolidated at a detainer action.
You want to reserve any time for rebuttal?
Pardon?
You want to reserve any time for rebuttal?
Yes, 5 minutes.
Okay, you already got it. Okay, sorry, go ahead.
A detainer action filed by the appellee against my clients, Vicki and Ernest Hance. JCR was the winning third-party bidder at the foreclosure sale. There's also a lawsuit filed about a month after the detainer where Vicki and Ernest Hance filed suit against JCR and the mortgagor, Nation Star Mortgage, for a wrongful foreclosure. Now, the issue presented in both cases is really quite simple. It comes down to who has priority, a wrongfully foreclosed homeowner or the winning third-party bidder at the foreclosure. This court has said, well, in Nashville, the issue of these FEMA mortgages, they're all the standards. I mean, the Court of Appeals has cited all the different clauses through the years, but this one's a little different because we're actually asserting under Section 19, which is borrower's right to reinstate after acceleration. Now, this court has said over and over, I cite in my brief and kept it simple, it must be cut and paste almost by now. This court has previously held that a defendant may defend against an unlawful detainer action by showing wrongful foreclosure under the deed of trust. See City Mortgage versus Drake. There is absolutely no doubt that a wrongful foreclosure can be raised as an affirmative defense to an unlawful detainer action brought by the purchaser of property in foreclosure. City Financial Mortgage versus Beasley. Holding that wrongful foreclosure due to a violation of the express terms of a deed of trust is a defense to a detainer action. Moreover, a foreclosure sale held pursuant to the applicable deed of trust requires strict compliance for the conveyance to be valid. Wells Fargo Bank versus Lockett. None of those cases is the sale to a third-party bidder. My opponent and I think we've researched cases going back 100 and some years. Neither of us has cited the court explicitly to a case that says which has priority, the third-party purchaser to wrongful foreclosure or the homeowner when it comes to the residence. And that's the issue today. We've cited you cases. There's really, if you want to go through all the minutia of the affidavits and the motion for summary judgment, what happened was the Hances, Vicki Hance got cancer, quit working, had medical bills. They got into trouble financially, couldn't make their $600 a month monthly mortgage payment. They discovered that if there was a foreclosure pending, Mr. Hance's 401k would fund the reinstatement. All they needed was the letter saying there was a foreclosure, which they received on like July 7th. They started attempting to get the 401k letter. It's a term that they use in the industry, a 401k letter, from Nation Star Mortgage. They started on Monday morning, July 10th. I'm not going to bore the court with details, but they kept giving a letter that said the amount to cure is as of the day before this letter is this amount. And the 401k people kept saying, we need an amount that'll cure, that we can pay. And it goes on to that, on, and there's recordings, not all of them, of Vicki Hance's conversations where she keeps more and more frantically saying, we need to get this nailed down. The deadlines come. She's told, don't worry about the 5-day deadline before the foreclosure. We'll take your money. She's still going back and forth. They finally wire the money at about 4 o'clock, August 7, the day before the foreclosure. There is a phone call from Nation Star, the employee they're dealing with in those last days, after 6 o'clock that day. The Hances both say, because they were listening, Miss Vicki Hance was doing the phone call, Mr. Hance, he was on speaker, Mr. Hance was listening. The fellow said, I can see you paid it, I'm going to stop the foreclosure. They filed the lawsuit. That's in it. I mean, the entire time, that recording was the win or lose of this case. That recording has not been turned over. Other recordings have. You have the transcript of them in the record. The foreclosure wasn't stopped. The employee marked the computer reinstated mortgage. JCR was the winning bidder. They overbid the bid. Nation Star, everything goes along fine till JCR's representative shows up August 23rd, says this is my house. Whereupon chaos reigns and Nation Star attempts to set aside the foreclosure and goes to JCR and they say, well, that'd be fine, but we want $20,000. They say, we're not paying $20,000 and we're not returning your $6,700 you sent to Cure, and we're not giving you the amount that was overbid. You're just going to have to move out. So we have a good wrongful foreclosure case. This is not just we didn't get notice. They did their best to comply with that deed of trust, and they were thwarted completely wrongfully. Court has any questions?
I hear none.
Thank you.
Thank you. Hear from the appellee.
May it please the court, I'm Scott McCulley. I guess I've been a member of the Knoxville Bar for about the past 30 years, but I've recently moved back to Maryville, which is my hometown. So I guess now I'm a member of both bars. Just briefly, addressing Mr. Roberts' analysis of the merits of his case. Of course, that doesn't really concern us here. As the attorney for JCR, the bona fide purchaser, I would say I don't believe there's any proof that the bank ever said we will stop the foreclosure. That having said, let me address first, Mr. Moore didn't address it, and it's not in his issue, but there is in their brief some argument that JCR wasn't a bona fide purchaser in the first place. So let me just briefly address that. First, is an order dismissing this case showed they've acknowledged from day one that they have no proof of any facts that would indicate that my client's not a bona fide purchaser. They've admitted that. He alleges in his brief that there's a fact out there that somehow there has to be some sort of investigation done by the bona fide purchaser. They don't say what that investigation is, and I would submit that there's really no authority for having to do anything. My clients did have a title search done. It revealed no notice of any claims against the bank. There's also an affidavit in my motion for summary judgment by Jim Bondard, who's a title attorney here, and he opines that there was nothing recorded in the registrar's office that would give any indication that anyone is not a bona fide purchaser. So I think it's pretty clear that we are a bona fide purchaser. I just wanted to address that, even though, again, it's not really their issue.
And that was the basis of the trial court's grant of summary judgment, that your client was a BFP and...
Correct, Your Honor.
Okay.
So I really don't think there's a dispute. I just wanted to address that because of what they put in the brief. If we do have a bona fide purchaser, and I think it's clear that my client is, they're seeking to void a deed, trustee's deed. They didn't name the trustee as a party, but they're seeking to void this deed. They've really not cited any authority, and Mr. Moore and I agree. We've not found a case on point, but they've cited no authority that would allow what he's asking for in this case is to void a deed to a bona fide purchaser. The only authority or only instance where I've seen some of the cases talk about these inadequate price cases, and then there's a whole litany of inadequate price cases. But what the courts have said is that you have to have some sort of malfeasance from the trustee or the lender that contributed to an inadequate price. And of course here, they didn't even make the claim inadequate price. And they've not cited any of those cases, probably because they realize they don't apply here. That's the only authority I've ever seen for setting aside a deed. The Sixth Circuit has opined on this, and this isn't included in my brief. It's in the matter of Harris versus LMV Corp. That's number 3-120552, 214 Westlaw 3015293. And I apologize that I'm not included. I didn't see it. But in that case, in this court's appellate case, which is Bank of New York versus Mellon, and Bank of New York's Mellon versus Helen Chambers, which is second of these Bank of New York versus Mellon's cases. But anyway, they cite to the circuit court case, a Sixth Circuit, that says, though there are no specific elements of wrongful foreclosure to state such a claim, the claimant must show that a legally held, conducted, and consummated foreclosure involved irregularity, misconduct, fraud, or unfairness on the part of the trustee or the mortgagee that caused or contributed to an inadequate price. And again, they've not even alleged inadequate price here. The law, statutory and case law, I think clearly protects bona fide purchasers. There are the recording statute, the foreclosure statutes, which are cited in my brief. And of course, the statute itself, as well as the court's interpretation of that statute, says voiding is not a remedy. You know, they can sue the bank, which they've done here, but you don't comply with those statutes, you can't be voided. And Mr. Moore is
Make
correct.
sure, I'm sorry, counsel, it's your position that even if the mortgage holder, Nation Star, had no right to foreclose, and I know that we're not answering it here, but that even if they did, even if Nation Star had no right to foreclose, your client bought it as a BFP, and they get the property.
That is correct, Your Honor, and they certainly have their remedy to go after the bank for damages.
Well, your client would have a remedy to go after the bank too if the bank sold you your client something they didn't have a right to sell, wouldn't they?
I'm sorry.
Your client would have a remedy to go against if the bank sold you something they didn't have anything to sell. I would think you could proceed against them as well.
You're absolutely right.
Okay.
You're absolutely right.
I'm just trying to understand how you could have a foreclosure sale that, and I have no idea whether the foreclosure sale was or wasn't proper. That wasn't here. A foreclosure sale that for some reason is improper, and yet the BFP now has superior title to the original property owner. I mean, that's the sum of your position, isn't it?
Yes, Your Honor.
Okay. All right.
And I think the foreclosure statutes are somewhat indicative of what the legislature, this court, as well as the Sixth Circuit, has talked about with regard to these foreclosure statutes, that the legislature clearly didn't want uncertainty with regard to land titles. And I think that's why if you totally ignore the notice statute, the statute itself and the court have said your remedy's still not being void. And yes, we would argue that's the case with regard to a bona fide purchaser also. And if, I'll say this, if a bona fide purchaser cannot succeed at getting a case dismissed or summary judgment granted, that's going to greatly affect how people look at buying at foreclosures. And it's going to cause, and in this case it's taken, I think, 5 years on summary judgment. But if you can't get summary judgment and or order of dismissal, you're forcing a bona fide purchaser to spend probably more money than they're going to get when they sell the house, in addition to the years to try this case. Plus, the bona fide purchasers council, they're going to have to delve into this whole issue of what happened between the bank and the person that was foreclosed on. So from a practical point of view, it would create chaos, I believe. I do believe it's clear that JCR is a bona fide purchaser. I don't think there can be any question about that. I think the case laws that I've cited, there's also, of course, the recording statutes, which talk about bona fide purchasers. And there's also some opinions on RESPA, where a statute that was developed to protect homeowners, there's no remedy for avoidance of a deed under that. So even though those aren't their claims, I think all these cases put together, in addition to just the bona fide purchaser laws, which have been around for years, together, they just don't allow for avoidance of a deed. That's all I have. Thank you.
Okay, thank you.
Oh, I'm sorry, Your Honor.
No, yes, go ahead.
I meant to introduce Lauren Roberts.
Certainly.
She's here as representing the bank, and I don't think she's wanting to address the court, but I was remiss in not introducing her. Thank you, Your Honor.
Glad to have you here. We'll hear from the appellate rebuttal.
With regard to the issue of BFP, the only question really is, would they inquired to investigate whether or not the people in the home were fighting the foreclosure. Other than that, they'd qualify, which I haven't got a case to support it, but other than the normal investigations is required. Other than that, they're a BFP. As far as I can tell, that they're in the business. At the time I took his deposition, 11 of the 12 homes in their inventory, they bought at foreclosure. This court has said over and over, wrongful foreclosure in violation of that deed of trust is void. Void, over and over. I didn't read any exception there. This court went so far as in the Davis versus Williams, as to say, once the detainer action is final, the ability to assert wrongful foreclosure is res judicata. You're done. That is so strong that Paxton Roberts has filed a response to the show clause where she's told the court, just if I lose the detainer action, she's going to assert I can't proceed on the wrongful foreclosure because it'll be res judicata that there wasn't a wrongful foreclosure. I mean, what I'd like to see is the court give, or maybe the rights with regard to that, exactly that if there's a wrongful foreclosure and a BFP buys, they've got rights against the seller. What rights? I don't know. Yet that'd probably be back up here when we fight through the wrongful foreclosure action. But I think this court needs to stick with the rule that's established, that is, everybody understands until the homeowner has lost the detainer, they've got the right to assert a wrongful foreclosure. Been lots of articles written about it, been lots of opinions written about it. To carve an exception for a BFP, there'd be chaos. You know, we'd be fighting over who's a BFP and who's not for years to come. So I think it's clear the correct policy issue. The homeowner's rights should definitely have priority over a winning bidder that's in the business of buying foreclosed homes. Thank you.
Court's thanks to counsel for both sides. We appreciate your argument and your brief.